back to the program, the Vicki McKenna Show. Standing by on the Homesteader Store hotline is attorney Dan Lennington from the Wisconsin Institute for Law and Liberty. Opened the show by talking about the situation in Sun Prairie, and we'll summarize this really quickly. 4 freshman girls were in a PE class, and they had a swim unit. So they were in their swimsuits. They went into the girls' locker room to shower. They were showering with their swimsuits on. A boy, not a boy, an 18-year-old, so technically an adult, walked in, took off his clothes, and began showering with the girls. And they were exposed to his full frontal nudity and didn't know what to do. Classmates suggested they contact the administration, which was the right thing to say. And the administration basically just shined everybody on. Dan, am I kind of summarizing it really, really quickly? But the administration didn't respond in any way that helped those girls.
Right, and that's really the tragedy here. And hopefully this is a wake-up call to other school districts and parents and taxpayers around the state and around the country to start to think about what's going on in our school districts and our schools really protecting our children. The schools really have 2 basic jobs, right? They have to teach our kids and keep them safe. That's really all. Teach our kids, keep them safe. In Sun Prairie, they failed on both accounts. I mean, here's some simple questions. Who can be in a girls' locker room? Should girls have privacy in the girls' locker room? Can males expose themselves in the shower of a girls' locker room to girls? You would think that all of these rules would be worked out and laid out in a policy that everyone can see, that's prominently displayed. But no, after the incident, after repeated emails and calls and meetings with Sun Prairie officials, they couldn't even identify what the applicable policy was or how it worked or how it was. The parents were just told the policy is going to take care of it. And that's inadequate. It's sad. Girls who are the subject of sexual harassment should know exactly what to do. Every teacher who hears about sexual harassment should know exactly what to do. Every principal and administrator who hears an allegation of sexual harassment should know what to do. These teachers, administrators fell down on the job. They didn't know what to do. And anybody who's worked in the corporate world knows what they're supposed to do when there's a sexual harassment allegation.
100%.
And I'm sure you do at your job.
So this is a violation of Title IX, and it is also a violation of state statute 944.20. Indecent exposure is a Class A misdemeanor. So nothing. I mean, nobody knew or nobody was willing to do what they knew they were supposed to do. Because if you're a district administrator, I've got the Know Your Rights. Title IX prohibits sexual harassment and sexual violence where you go to school. This is a resource that is provided by the United States Department of Education. A school has a responsibility to respond promptly and effectively if a school knows or reasonably should know about sexual harassment or sexual violence that creates a hostile environment. The school must take immediate action to eliminate the sexual harassment or sexual violence and prevent its reoccurrence and address its effects. It then goes on to explain that the student is supposed to be given information and direction on how to file a Title IX complaint. And since we also happen to have this in state statute, someone should have picked up the phone and called the police.
Yes, so you're exactly right. Title IX imposes duties on public schools. They must have clear policies on sexual harassment, prominently displayed. Everyone should know what these policies are. When there's evidence of an incident of sexual harassment, Title IX, there must be like a Title IX official. There must be a Title IX official, a person who has that title, and they must reach out to the victims, offer supportive services, offer them the chance to file an official complaint or an informal resolution. And at the very least, parents should be called. That we hear this all over the state. We hear about these horrible incidences of violence in schools, and then we hear from parents, they didn't even call me. No one picked up the phone and called me and told me my son was involved in some sort of accident at school or was involved in a fight at school. Parents need to know about these things, and they have a right to know. But, you're right. There's state criminal law about adults exposing themselves to minors. It's our understanding that the SRO at the school, Sun Prairie Police Department, was made aware of that. I don't know how that is being handled by the Sun Prairie Police Department. But also there is mandatory reporting. If you are in Wisconsin, if you are a healthcare worker or a daycare worker, or you're a teacher or a counselor, and you have evidence, reasonable evidence that a child has been subject to abuse, and abuse can include any sort of a violation of a criminal statute that's meant to protect children, you have a mandatory duty to report. And Sun Prairie has sort of just sloughed that off as if an adult exposing themselves to a minor is something that doesn't need to be reported to anybody, and that it's sort of no big deal. I mean, the timeline of this is shocking, and this is why we're so upset. This is not really about this particular incident, but it's about how the school responded to the incident. The incident happened on March 3rd. On March 6th and March 10th, the assistant principal gained information about this and failed to act. She later admitted to parents, she said, "I should have dug deeper." On March 16th, there was a call from the principal apologizing, but promising that the policy, quote, policy addresses this situation, but is unable to identify any policy. March 29th, another email. Principal could not identify what policy applied. The first parent meeting didn't occur until April 5th, over a month after the incident. No answer to what was going to happen, no policy identified. It wasn't until April 10th that a policy was sort of magically identified. But the policy they identified puts the burden on girls. It says this: any student who has need or desire for increased privacy may be provided with access to single-access restrooms where such facilities reasonably available. It basically says, if your girl is upset about this, we're going to give you your own space. That's precisely backwards.
It's girl spaces. This is a man in a girl's space, and the girls are supposed to be the ones who have to be sexually harassed. And again, this falls under also criminal statute as a Class A misdemeanor in Wisconsin. So a crime has to occur, and then it's incumbent upon the victim to go and seek out privacy. That's Title IX inside out. That is not what this says. That is not what the federal law says, period. So why is the policy the inversion of federal law? And I'll tell you why. The policy is the inversion of federal law in Sun Prairie because the 18-year-old adult teenage man says he's trans.
This is a problem everywhere, and it's not just Sun Prairie where the policy is inverted. We've seen it in other school districts where they say, if you've got a problem with a trans person being in your bathroom, we'll give you a separate space. That's sort of the de facto rule, but in most public schools, and I encourage parents to ask, what is the policy in their district? The problem is, so Title IX is 50 years old. It was passed by Congress to give access to women and girls to sports. It is a statute that you would say is feminist. It is a statute that protects girls and young women. They are the beneficiaries of this statute. But now we have this transgender ideology in the Biden administration that wants to insert this gender identity into Title IX, but what they're not doing is they're not realizing the unintended consequences. And the unintended consequences is that women and girls are losing protection. They're losing protection.
They are. These are not unintended consequences. These are consequences everybody knows about and just doesn't care about because the politics lead on this. And so these girls, they can ask us for privacy. So I'm going to say this again. You have to have a crime committed against you and become a victim before you even know you're supposed to ask for privacy. So every girl in Sun Prairie School should ask for privacy. We all want privacy. All of us. We all want private spaces, 100% private spaces. See what happens when or even 20% of girls start demanding that. Then they would cough up an actual workable policy.
Every girl in high school, in middle school, and elementary school should feel safe in the bathroom, in the locker room. They should have the private space. That's number one. Number two, if they're the victim of sexual harassment, they should know what to do, and they should know what rights they have. And the caregivers, the principals around them, these are the people who say, I'm your real parent. They should start acting like it. If you want to be a parent, start acting like it, principal. Start acting like explaining what can be resolved and how this will never happen again and what the policy actually is. But they've offered nothing. They've offered neither safety nor privacy nor access. And what the Sun Prairie's response is, if you read it in the media, is we can't talk about this because of student privacy. The heck they can't. They can talk about their policy all the time, but they won't talk about their policy. You know why? They don't even know what it is. And they're afraid of what their policy is because they're afraid that they're going to offend somebody if they explain that girls get girls' locker rooms and boys get boys' locker rooms and girls have equal access to education and sports. They don't want to say that because then they're going to have to talk about what is a girl and what is a boy, and they don't want to talk about that. Well, I hate to be the feminist here, but but we need safe spaces for girls and women, and we need equal rights for all. And that apparently now that is the most conservative position you can take in America now.
I guess so. Equal rights and safe places for women and girls and equal access and safety.
Go back,
my goodness.
Go back 10 years and tell somebody that you and I would be talking about that. They'd say, you're crazy.
Yeah, and I would have said you were crazy. Dan, I'm running out of time here. What is WILL doing? Are you seeking resolution? Are you seeking a Title IX complaint?
We are asking for public records. We want to know exactly what happened here because we want to know how they failed and how the system broke down so that we can better educate other school districts in how they should fix their policies so that we can protect all girls and young women in Wisconsin and give them all the rights that they are due under federal and state law. That's all we're asking for right now.
Have the students been given information on how they can file Title IX complaints?
I'm not going to talk about the specifics of this case, but we would like all school districts to prominently display their policies. You went on the internet in 2 seconds and you found it and you just read what the Title IX rights were. All we're asking for is that information be provided to students so that they know about it.
At a minimum.
Yeah.
Dan Lennington, thanks very much for joining me on the program today. Wisconsin Institute for Law and Liberty. Find information about WILL, Wisconsin Institute for Law and Liberty, at will-law.org. And there's also a contact button on the website. There's also a donate button on the website. So if you like the work that WILL does, please make a donation because they don't charge. Good to have you, Dan.
Thank you, Vicki.